In this video, we will discuss mandatory arbitration clauses. Arbitration is a form of private justice, in which parties that are in a dispute do not go to a courthouse to resolve the dispute and do not make use of the state's judges or juries. Instead, the dispute will be resolved by a private party, the arbitrator or arbitrators. Arbitration is by agreement, in which the disputing parties agree to have the private party, the arbitrator, resolve their dispute. So where's the agreement to arbitrate? Often, it is written in a contract, where the contract includes a provision or a clause which provides that instead of going to court, in the event of a problem, the parties promise to choose arbitration, which means that if there is a dispute between the parties and one party wants to go to court, the court may have to decline to hear the dispute because of the arbitration clause in the contract. In other words, where the arbitration clause is mandatory, only the arbitrator and not the court can decide the case. So why is there controversy over mandatory arbitration clauses? Sometimes people sign contracts, often very long contracts, and are surprised to learn that they agreed to arbitration. And as a result, they may no longer have the right to have their case heard in a public court. To summarize, arbitration is a system of private justice. A mandatory arbitration clause is an agreement in a contract that requires the parties to arbitrate instead of going to court. Mandatory arbitration clauses are sometimes controversial because the signatory has lost her access to the courts.